To His Excellency, President of the General Assembly, Mr. Abdullah Sahad, and to all distinguished representatives of the Member States gathering for this auspicious day, International Mother Earth Day, greetings from New Zealand. In the beginning was the potential, and from the potential came the many different stages of darkness and night, from which was derived the Earth Mother Papa Tuanuku and the Sky Father Ranginui. These primal parents begat the gods of all the different realms, including Tangaroa and Henemoana, the god and goddess of waters. I have been asked to speak about one of the waters of Tangaroa and Henemoana here in New Zealand. I refer to Te Awa Tupua, the Whanganui River, the third longest river in the country. It is situated in the North Island of New Zealand and stretches for 290 kilometres from the central plateau to the sea. Prior to the arrival of Europeans, different reaches of the river were densely populated by Maori living in kin groups or tribes. These tribes exercised authority over the various reaches of the river. For them, it was an ancestor, it was a symbol of tribal identity, it was a site of many Maori villages, it was a communication and transport route, and finally, it was a famous fishing ground, particularly for eels. The importance of the river is captured in the saying, Ko au te awa, ko te awa ko au. I am the river, and the river is me. And when the Whanganui tribes come together, they talk about how important the river is to them in these terms. There are a number of tribes associated with the river, however, but it is the Whanganui iwi who have primary association with the main stem of the river. Due to colonisation, they were marginalised from caring and exercising their stewardship over the river. And for approximately 100 years or more, they litigated in the courts to try and have their right, which they said was protected by the Treaty of Waitangi, protected and recognised and legally enforced in the courts. They were unsuccessful. So in 1990, they filed a claim in the Waitangi Tribunal, the tribunal established to hear claims against the New Zealand government. And the tribunal upheld their claims in 1999 and recommended that the government and the tribes negotiate a settlement. That settlement was achieved in 2014. And then in 2017, the settlement was codified in Te Awa Tupua Whanganui River Claims Settlement Act. And this is the statute or the law that recognises the river as a legal person in its own right. So since 2017, progress has been slow, but all management entities for the river have been constituted, and the Settlement Act, which required that the strategic plan be produced by a number of stakeholders, including environmental groups, has been completed in draft and is about to be circulated to the public. There are also tourism and regeneration projects. So in conclusion, the settlement was, at least for the tribes, a recognition of their right to exercise some authority over the river. The legal personality component of the settlement has given all New Zealanders the opportunity to enjoy and appreciate the river as a living entity. It has also raised public awareness about the relationship of the tribes with the river, which they consider to be an ancestor. And through the settlement, the Crown's obligations under the Treaty of Waitangi and the United Nations Declaration on the Rights of Indigenous Peoples have been somewhat fulfilled. There are still critics, but that's for another paper on another day. This is all from me, Caren Fox, Deputy Chief Judge of the Māori Land Court, signing out.